Yes, I request participants or whoever it is possible to switch on their camera, so I'll get the feeling that I'm talking to people. And since there are 30 people around, so it would be great if at least one or two can switch on their uh, camera. I will be sharing a presentation. Just a second, it's complicated. Just a second, let me share the presentation. Just a second. Can you see the presentation? Hello.
Yes, sir.
Thank you. Thank you very much. So basically today's topic is the IBC and various challenges to the various industries in the IBC. So first, we will look into the fact like सर आपकी somebody has switched his mic on और हम आपकी private discussion सुन रहे हैं सर. Hello. Okay. So first of all, I wish to break down the topic in various sections. So one will be there will be performance reviews, procedure challenges, legal challenges, commercial valuation, sector specific challenges, cross border, and the proposed reforms. We will try to cover all the topics as much as possible. All of you are welcome to ask questions because all of you have done probably a lot of insolvencies. And Akhilji, I am very thankful to switch on the camera. So that really helps. Okay, so what the IBC has done to the entire insolvency process, the insolvency process in the IBC has brought in few fundamental changes. And these fundamental challenges have been applied across all the industries. Thank you, sir. Rangaswamy ji, thanks for switching on the camera. And what are the fundamental changes? The fundamental changes which IBC has brought in is creditors in control, the mechanism of the insolvency profession, altogether a new class of the professionals which are the valuers, and ultimately the object is to maximization of the value. This was the object and the fundamental changes were brought in. Except for couple of industries, one is the real estate sector, one is the financial institutions. The entire mechanism has been made applicable to everyone, with one more notable exception of the MSME sector. So in the IBC, you will find specific provisions regarding the real estates, home buyers or allottees, whatever they used to call them. Secondly, financial institutions, that it can't be initiated unless there is an approval of RBI and etc. And thirdly, for MSME sector, which is pre-packaged insolvency profession. Except these three specific exceptions, the IBC is one fit size for all. everybody who has committed a single default has to be looked from the same lens and has to undergo the same process. The process is simple. Whenever there is a default is skipping one installment or non-payment of one invoice, which is more than of 1 crore of rupees, the company is dragged into the IBC. Once it is dragged into the IBC, the claims are invited by the resolution professional, where most of us uh, come in planes one way or another. They are supposed to manage the company as a going concern, constitute the COC, and COC, with COC's approval, the IM is invited, the resolution plan comes, whoever approves the 66%, it is approved, and he gets the company which is supposed to run thereafter, and if nobody comes, it goes into the liquidation. This is the standard pipeline applicable for all cases. And that has given rise to some unique procedural legal challenges. And the wisdom of the COC has been repeatedly questioned, and for foreseeable future, it's going to be questioned in all forums. So, and with the specific industries, there are industry specific challenges as well. So, this is what we are trying to cover. So, in the procedural challenges, we will look into the systematic bottlenecks, NCLT and NCLAT, why the proceedings get dragged. Is there any solution or is there no solution, and how to navigate through them? Legal challenges, moratorium scope, eligibility application 29A, section 12A, commercial wisdom, and commercial challenges. Valuation paradox, liquidation value, and haircut dynamics, like whoever is taking the haircut and in what sense they are taking the haircut, etc. So I have taken these figures from the internet. I will re-verify it and before sharing the slides. So broadly speaking, thousands of the companies have been resolved. It's more than 1,000 now. The creditors are huge. The recoveries are less than 40%. The timeline, which was sacrosanct, should have been completed within so and so 300 and something days. Now, average timeline is going beyond 800 days. The number of pending cases is about 30,000. And these are the rough statistics I just tried to find out. I will put a footnote of all these statistics. So idea is that IBC is, there are a lot of seminars which says whether the IBC is a complete failure or a very success. If we look IBC on a micro level, it's a failure. Because as a resolution professional, as a creditor or as a promoter, if you go before and stand before the NCLT, there is only a sense of frustration and you will find many loopholes as such. But if we look at the overall statistics and compare the performance of this law vis-a-vis earlier recovery laws, which is Debt Recovery Tribunal, SARFAESI Act, or even prior to there is an Insolvency Act of so-called Provincial Insolvency Act, we see a phenomenal better performance for resolving insolvencies of the companies and the personal guarantors. So the comparative success of the IBC across all the sectors compared with the previous existing, the structure which existed previous to enactment of IBC is really good. But it is so far not able to meet the aspirations of the people which are right now with the IBC. So promoter wants clean exit. They are not getting it. Multiple applications against the promoters are pending. the home buyers or the allottees want quick possession, they are not getting it because they are difficult to resolve the insolvency real estate sector. The financial creditors wants to recover, but ultimately lofty object of the IBC is not to recover but to resolve the company. So there is a dichotomy between the recovery and the resolution. Then similarly, the employees and the other operational creditors, though they are forced to resort to these proceedings, if they are unable to recover prior to admission, they are not getting anything out of the insolvency process. So overall, if we look IBC as from the industry perspective on a macro level, it's a success in terms of the figures. And when those figures are compared with the previous legal system, and at the micro level, all the stakeholders are unsatisfied who are dealing with the process and day in and day out basis. So this is it. So what are the procedural challenges? So the procedural challenges is inbuilt into the system. The first and the foremost procedural challenge which anybody faces is struggle to get the case admitted or not admitted at the stage itself. The first thing which any creditor wants is his petition should be admitted as soon as possible as the default is proved. But the cases can't be decided without following the natural justice, and which is an essential and key element of any judicial system. So there is a lot of delay in admission of the cases. There are some genuine challenges as well as there are some fake challenges. Genuine challenges to the NCLT is that some of those insolvencies are pure recoveries, and some of the insolvencies are not instituted for the purpose which they are designed for. So, as a tribunal, the tribunal has to scrutinize meticulously each case, which one is genuine, which one is not genuine, which meets the criteria, which doesn't meet the criteria. And ultimately, that leads to litigation. That's the first and foremost challenge. Thereafter, entire CIRP process is riddled with the applications. The reason an application can be filed, the number of stakeholders in any company is huge. The threshold for invoking the insolvency is 1 crore. So if somebody has defaulted 1 crore, it can be reasonably expected that they are at least 50, 60 crore company or 100 crore company. If this is this big, the stakeholders maybe it won't be 5 or 10 or 2 digits, sometimes it's 100, 3 digit, 4 digit numbers. All these people are differently affected by the insolvencies because of the moratorium, because of the stuck up money, asset, etc. And since the interest of all these people vary, they move applications. So by the time a resolution plan comes up before the NCLT, there are 30, 40, 50 applications, or sometimes more than that. And that has to be resolved. And over the period of time, there are hundreds of applications, particularly in the real estate entities, which are to be decided by the NCLT. And the entire system remains overburdened by these applications. There was some proposal to root them out, but this is what it is. Then the matter goes before NCLAT, and all these matters, since the financial stake involved of the stakeholders are high, is litigated up to the Supreme Court. And once the matter goes to the appellate forum, be it NCLAT or a Supreme Court, the timelines becomes relative and the things become very difficult to implement. Thank you, Gauraji, for switching on the camera. Then the next challenges. So 29A, 12A, CEO commercial wisdom, avoidance transaction, etc. So in these challenges, so let's try scope of the moratorium. Once the moratorium is imposed, everything comes to a standstill except the thing that it has to be legally kept as a going concern. It can only do the business. But hardly any person wants to do a business with a company which has been involved or which has been admitted in the insolvency. Because of nobody wants to do the business, how it can be done and how it cannot be done remains a challenge. Then section 29A eligibility is another challenge. 29A eligibility is a challenge because there are exceptions to MSME. The definition of the MSME has been enlarged, and overnight the people can get the registration. And further, that definition is not very easy to implement, and there were divergent views of the NCLTA regarding whom to apply and whom not to apply that qualification. Then section 12 withdrawal is another challenge. Everybody wants to settle the case. There was a mechanism where the people used to go in 12A and go before the appellate forum and say that we really want to settle the case, and appellate forum used to give the relief. Thereafter, the byju's judgment come in. And in the byju's judgments, uh, it was held that the tribunal do not have the power, it is the COC's power to decide. So essentially, in all the cases, the COC's commercial wisdom has been given preference from the NCLT, NCLAT to the Supreme Court. Because of it, what happens is that if somebody wants to settle first, he tries before NCLT, then he tries luck before the NCLAT, then the Supreme Court, and ultimately ball comes back to the COC. Lastly, the thing is the commercial wisdom of the COC. The idea was that the money has been borrowed by the company, and the assumption was made that they have the knowledge of the business. But in reality, most of the people who form part of the COC are from the financial institutions who were in the business of lending business. And if they understand some business, it is the business of lending, not the day-to-day running of the business of a company which is a going concern, manufacturing concern, or any service industry or etc. Fact coupled with the fact that one, they do not have the experience of running. Secondly, these are not the people who have taken up the business as a challenge. They are part of an organization which is in the business of providing lending. So their interest in resolving is limited. Further, their power to take decision on the spot is also limited. They are answerable to somebody superior, and only when the decisions flows from the people who are at the top, they take a decision. So there is a delay in decision making process. Thirdly, with the operations, the people who are familiar with the insolvency is the operational creditors, because they were the provider or the customers. They were the one who were providing raw material, or they were the one who were buying the goods and services from the industry. So they have at least some understanding or a better understanding of the business than the people who are providing or lending the money for getting the interest. But they have been kept out of the entire process for some good reasons. Because of which, what happens is that the person who is taking the decision is far removed from the industry, and the person who can take the decision is out of the system. He is given as the last priority for some reason. And that makes the decision-making process itself less sound and less foolproof. Then there are avoidance transactions which happens during the CIRP process. It has been time and again and repeatedly projected that all the companies have gone bad because the person who was taking the decision has done something illegal. It's an inbuilt biased presumptions in the minds of many that they have taken something decision which is not so legal, or they have siphoned off the money, and therefore every transaction which is falling into the look back period has to be looked from the eye of a suspicion, and that has to be brought before the NCLT. It's very difficult to get the cooperation from the promoter after you are accusing them of siphoning of the money. And you are not getting the cooperation from the promoter, then it is very difficult to resolve the insolvencies as well. Because they are the people who know the business. They maybe themselves may be the reason of the failure, but their understanding of the business is far greater than any other stakeholders because they were running the companies. There they have paid the money, why it has been paid, why it has not been paid, why that particular entry was not made or made, etc., etc. And therefore, it has. The next challenge in the CIRP process is the valuation paradox. There is some saying which says that value lies in the eyes of the beholder is somewhat correct. For some person, the value could be very high. For some person, the value could be really less for the same property. Ultimately, it's not a straightforward principle as it is projected in the IBC. The IBC says one value to be appointed, one to average out, etc., and you take the liquidation value that has to be paid to the operational creditor. No. The system is flawed. Why? Because there is no empirical data which is available to the valuer where he can reach a correct decision. The value is something, if the market is commoditized, say take an example for a Parle-G biscuit or for a surf, everybody knows there is an MRP. This is the value which can be realized, this much is the margin, this is the tax. But in most of the cases, it's a plant and machinery or it's a real estate, etc., or it's a business as a going concern. So values are normally very far from the reality and hypothetical. Assuming that some paper mill is being in the IBC process, it might have very great value for the person who is competitor. But if there is no competitor in the area or the competitor is not willing to buy, the only other buyer is the property dealer, for which the value is the circle rate. For him, whether the factory is running or not running doesn't matter. So the valuation is, and then the liquidation value on the top of it. If sometimes you feel that the values have been given in the IBC process for the sake of it, because the backup data to justify that value is completely missing. How? There are very few valuations where the registered sale deed are put for the valuation of the company. There are very few, most of the time, if somebody is doing the valuation, there is often sentences that we went into the local area, we made the inquiries, and as per the inquiries, this is the value, and therefore we are doing permutation, combination, according to us, this is the value. Once your valuation itself is based on permutation and combination built with an assumption, how you can expect a resolution plan which has come based on that valuation will be sound and realize the maximum value? Two, assuming that that value is not correct, then there is no chance of any operational creditor buying that idea that I am entitled only to this much of value, because in their eyes, it is the running factory which they have seen while doing the business. Or for the customers, they have seen the factory which was running, it was so much of the worth, and based upon seeing the factory, they entered into a commercial transaction or relationship. So these are the chair. And what is the result? The result is that whoever is giving the resolution plan will see that how much maximum haircut I can apply. So to maximize my own wealth. And the race is to give maximum to maximum haircut and somehow to manage the system, because he is trying to go into a territory which is unexplored. And that's how the challenges keep on building in various industries. So, what happens when the process gets delayed? NCLT delays, everybody knows. I need not explain because all of you are insolvency professionals and etc. You must have faced multiple delays. You are standing in the court for the whole day and the item is not reaching. Sometimes the bench is only for the half day. There is shortage of the judicial members or technical members. Infrastructure is very deficient compared to the normal courts, and the registry is ill-equipped. Like you file it, and you have to. It is your responsibility to make sure that the paper reaches to the bench, and it takes forever in some registries to get the documents listed, etc. Because of the delays, the asset quality goes decays. It's a plant and machinery or anything else, it goes. People leave the company as soon as seen. There are multiple cases where once the RP goes and uh, just a second. There are multiple cases where the RP goes and uh, the people started taking long leaves, or sometimes they started doing what they can say is that hunting for another job. So the people are not there who can do the work or turn around the company. So these are the challenges which keeps on bothering all the stakeholders. So what kind of problems are even greater than what we have seen so far? One of is promoter challenge. Since the promoter has known the value of the company, he is one of the person who can realize the most of the value. When he finds that actually it is going for far less than what he can actually capture the value, he tries to take it back. Sometimes the ways are legal, sometimes of the ways are not so legal. And therefore they have enacted 29A to avoid the conflict of interest. But 29A cannot make the things foolproof. So there are promoter challenges, Section 7 challenges. Interlocutory applications we have already discussed. So in interlocutory applications can be moved by all the companies, and some of them are really genuine, but some of them are frivolous as well. There are invariably the tax authorities filing the application for admission of the claims, PF authorities filing application of the claims. Sometimes even if they are intimated, they don't file it on the time and thereafter files various applications. Then 60 subclause 5, which says that anybody can do it. So all kinds of dispute comes. The idea of the IBC is to resolve the company. Company cannot be resolved when there are existing dispute. And those disputes remains unaddressed, and there is hardly any mechanism whereby they get decided. Because the process is summary in nature. How much money was due? What was money due? What could have been the actual claim? What is the realization? Nothing is that happening in the entire process. What is getting determined is claim and how much haircut you are getting. Then PMLA and ED attachment is an issue. Like on all the old companies, there are Prevention of Money Laundering Act and ED Act. Whether this which one will supersede, if there are companies where the ED has attached the assets and RP is sitting, now there is no asset which RP can deal with, and for years together the insolvency professional is hanging up with those assignments for No reason. Even if they want to discontinue, there is nobody who wants to continue in their place. And there is a challenge itself. The challenge is when the business was going and it was going well, lot of things which have been shown on the balance sheet were not the correct picture of the actual transaction taking place. Once the business has gone bad, everybody started questioning those transactions for which there is no answer, which can be given by the people or who don't want to give the answers. All these transactions get questioned in the PMLA proceedings, ED proceedings, and simply there is a presumption in the favor of these authorities. If we typically go through the PMLA provisions, it says that unless proven that I am not guilty, it is presumed to be guilty. The PMLA is one of the laws. Like if you see the IPC or Bharatiya Nyaya Sanhita, there is a presumption built in the favor of the accused that unless he is proved guilty, he is innocent. So the trial takes place. In the trial, it is being shown that, okay, these are the evidence against the person, and therefore he is not guilty. But in PMLA, it's reverse. So it's very difficult to remove the attachment. And the transaction itself is a complicated. Plan approval delays. So there is a lot of delay in approval of the plan for multiple reasons. Because by the time the plan comes, all the applications get compiled at the doorstep of the NCLT tribunal. What happens is that all these applications are supposed to be decided. Some of them, they say that it will automatically follow whatever the course and the plan is. But the file becomes bigger. It is a very tedious and tough task to decide all those applications. And the factors which are to be taken into accounts are huge. There are various innumerable challenges. And all the plans which have been approved will be taken into challenge before NCLAT, which leads to further delay. So these are the challenges. So what has happened is like huge delays, and this is faced by all kinds of industries. Then in the beginning of the presentation, I have stated that there is a special category of the companies where a sectoral regulation has been made under the IBC. This is MSME. In MSME, they have provided for pre-packaged insolvency resolution process. The pre-packaged insolvency process is designed for these specific group of companies for the reason that there was an assumption while framing the regulation that these things can be resolved faster. They are low-hanging fruits. And the company will grab this opportunity to do it. The pre-packaged insolvency, as the name suggests, for MSME means that everything which happens into insolvency is done almost prior to the insolvency, like collection of the claims, drafting of the plan, approval of the plan. All these things are done pre-arranged even before the petition is filed. Once the petition is filed, and if there is no haircut to the operational creditor, it straightforwardly goes, there is no challenge. But if there is no haircut to anybody, operational creditor, why the financial creditor will take a commercial decision to take a haircut? Nobody will ever do it. Commercially, they won't be able to justify their own decision in front of the people whom they are reporting. The second challenge, if the plan is going for a toss and there has to be a challenge to the plan, the best plan or best alternative plan as the PPIRP prescribed, then why the promoter will take the risk of running into PPIRP? He doesn't want to lose the company, and that is the only reason he came to. And the cost involved in getting all the consent from all the stakeholders for approval of the plan is itself is a challenge. So despite the fact that there is a huge contribution of the MSME sector in the industry, there are numerous MSME companies which are in the IBC. The PPIRP did not become a powerful tool, and in the industry, it failed to get any traction as such. So the idea is uh, the idea is that despite or with all good intentions, this was proposed by the government, but since it's not commercially viable for the people who are in the business, they did not take it, and it is hardly any success. I think there are around 11 or 12. It's not in 3 digits, it's only 2 digits which plan has been filed and so far approved. Despite the facts that MSME may be around 30% of the industry, 40% of the GDP, and etc. and etc. And large number of the people are employed in the MSME sector. So, what is? Let me go to the again the challenge of the moratorium. So, what I have made a short chart. What are the challenges and how the NCLT is trying to remove it? So there are lots of applications regarding the contractual breaches, and the people are using the moratorium as a sword as well, particularly in the personal insolvency cases and even in the insolvency cases. Theoretically, it is being said that it can't be used as a sword, but it is being used when the company is in the default and if it is finally admitted in the insolvency. The best thing the promoter can say to all the people who are demanding the money is to approach the RP. Then another challenge is leasehold rights. The leasehold rights cannot be terminated during the moratorium, but at the same time, the title is not with the company. And since the title is not with the company, there are various challenges as to how these titles will get transferred in the resolution plan. Though there are some few of the rulings up to the Supreme Court which says that it will go according to the resolution plan. But at the same time, there are still challenges which are pending, which says that only the part of the title which is lease may be transferred, but not the entire title. And along with there comes the challenge of cancellation of the lease and etc. Then criminal proceedings is a challenge. The Supreme Court has held that moratorium does not cover the criminal proceedings. 138 cases will go on. Now, if somebody asks a question, if it is a recovery proceedings and it has been promised as a IBC that it will resolve everything, then how the recovery proceedings can continue? At the one stage, you are saying that it's not recovery, and another stage, it is saying that it is a recovery. Assessment during the EPFO assessment during the moratorium. Similarly, the PMLA Act and others. So these are many of the challenges which comes during the CIRP process. And in fact, in more than 30,000 cases which are pending, half of the benches are not performing or not performing, like can't even assemble because of lack of resources and the manpower. most of the people, because of the nature of the entire challenge in the IBC process, are not even taking up active authorization as well. The timelines are never being followed. And the infrastructure deficit, like in Chandigarh, one of the courtrooms got flooded during these monsoon seasons. The proceedings has to stop. Even in Delhi NCLT, once there is a structural audit which took place. Uh, the NCLT itself has to split its time between the company cases and the IBC cases, so they are not getting preference. But sometimes they are important as well because they are the acquisition merger cases where the scheme has to be approved and etc. And the hearing is the part of the system. The hearings and adjournments are the uh, things which is bound to happen. So 29A, what is the challenge? So in 29A, the what happens is the scrutiny of the beneficial ownership takes place. The typical way it is being done is by looking at the definition of the related party and what is the relationship vis-a-vis the ex-promoters in any of the way. There is a long list of the things. But if somebody wants to acquire a company and gets a backdoor entry, there are two questions. Whether are you preventing the person who can realize the maximum value to participate in the process on the assumption that he has done some misdeed and therefore he should be kept out. That's a presumption on the basis of which 29A operates. Even when the 29A was there, they realized that it is not the case for all. So they created an exception for the MSME. That exception itself allows, so there are two class of the people which the IBC creates. One, who are not MSME and who are the MSME. If they are MSME, then certain exceptions of the 29A are not applicable to them. If they are not, then everything applies. So a person is deemed to be non-suited before a conclusion is reached that he was responsible for those kinds of activities or not. One of them is avoidance transaction. But normally the application for avoidance transaction cannot or is not getting decided prior to the approval of the plan. So the resolution hijacking is taking place. The court is drawing only inferences, and on the basis of the inferences, the things are happening. Because the system is not perfect or is in the process of perfection, which is yet to come, there are people who are able to take advantage of the system. And the reason it is not so effective and why these transactions are happening is whether somebody is relative or not. If commercially it is viable, the people will regain the control of the companies if they can realize the commercial value with the help of the person who is not related parties. So original timeline is 330 days, average is close to 180 days, 800 days almost. And in 100% cases, there are delays. There was an interesting case in the Kalyani or the Bhushan Power and Steel. In this case, what was happened is that when the timeline question has arisen, the court took the view that they are discretionary for the court but mandatory for all other people. Then in the Bhushan case, which went into the review, and the review was allowed, if we see the original order passed by the Supreme Court, which was not reviewed, there is a paragraph which says that the proceedings itself are bad if they have not followed the timeline. So, there are possibilities in the future that the Supreme Court might overturn its own decision at some day and the things will change. The section 12. So, #12A has to be seen with the perspective how the company can be taken out of the insolvency process. So there are multiple windows available in the IBC where a company can be acquired. Typically, there are 3 windows. First one is 12A, second is section 30, third is the liquidation. The company, if somebody is interested in the company, these are the 3 stages where a company can be taken out. So as far as the 12A is concerned, this is very lucrative for the ex-promoter for the reason that at this stage, sometimes even the COC is not constituted. Even if it is constituted, section 29A is not applicable at the stage of 2A. The only challenge is to get the requisite 90% of the threshold. So, assuming a company which has only 2 creditors and one person holds 91%, but the insolvency has been commenced by another person who is less than 10%, then it becomes a loop. Despite the fact that they want to create an insolvency, it can't be created because 90% are still supporting. So it's because of the 90% is achievable only in the companies where number of the creditors are less. If the financial creditors are too many, it is very difficult to get their consent. So 12A is successful only when the number of creditors are less and the company has enough money to satisfy those 90% of the creditors. Secondly, after the Supreme Court's judgment in the Byjune's case, where the NCLAT can no longer approve those or set aside those insolvency where the settlement has taken place. It goes before the COC. And once it goes before the COC, it becomes very difficult for them to get the 12A approval. I think that the session is becoming quite monotonous. If anyone has any questions so far. Or
I have a question.
Yeah, thank you, sir.
In the case of a 12A, when the claim of the operational creditor in respect of interest is not accepted by the RP, and 90% of the COC agreed on 12A petition, and NCLT has accepted the 12A petition, the operational creditor went to NCLT because the Form FA was not signed by the applicant. Applicant is the operational creditor.
Okay.
All the dues were settled by the suspended director. On the technical ground, NCLT has disallowed that approval of NCLT. and reinstated the CIRP.
Okay.
After 2 years, almost 2 years in NCLT, the interest claim, even though it was not accepted by the RP, to a certain extent was settled by the suspended director. But the operational creditor happens to be a foreign company, did not file the Form FA, did not pay the CIRP cost. What is the solution?
Solution is the CIRP will go on, sir. If I have understood correctly, 12 has been disallowed.
But he is not, the operational creditor is not attending the hearings.
It's less likely to attend, but there is no provision which says that if in case the 12A once misses the 12A bus, then the next stop is only section 30. So there is no in between.
So can the NCLT decide on Rule 11?
Rule 11 is inherent power.
Okay.
Inherent power, not inherent actually, the residuary power actually. If it is accordance with the IBC and there is no specific provision, then that can be exercised.
So what is the end? See, almost it is 4 years. For the last 2 years, CIRP cost was not paid. And the settlement of operational creditor is over. There is nothing for the suspended director to pay. He wants to continue the business. He wants to get the CIRP closed.
Right, sir. So if the question is like this, what is the solution?
Yes.
So if 12 is not there, then even if the CIRP cost has not been paid, the RP can't withdraw. The promoters can't withdraw. There is no window provided in the IBC where the promoter can be allowed to run the business or the CIRP can be set aside. In your case, it's a very typical factually oriented case. So what could be the solution is that somebody can go challenge it before the NCLAT. Even if post rejection, go to the Supreme Court. 11 will not help. But if the Supreme Court decides to exercise the power under Article 142, it can be done. So, in some of the cases, in the insolvency cases, where this kind of situation has arisen, I know at least 2 decisions where the Supreme Court has exercised its power under Article 142 and set aside. As far as 11 is concerned, the reason why they don't exercise the power, because that power is circumscribed by the provisions of the IBC itself. It's not like an inherent power where they can do anything to meet the ends of the justice. That power in the entire system is vested in only one court, and that is Supreme Court of India. So if somebody can take this case again back to the Supreme Court, and if the Supreme Court is convinced with the logic that there is no substance in the CIRP, as the operational creditor who has initiated the CIRP is not pursuing it, there is nobody who wants to pursue it, the promoter wants to run the company, there is hardly any creditor or something else, then it might decide. So how many creditors are there apart from that one operational creditor who has initiated the insolvency?
All the creditors are settled.
So there is 0 creditors now.
Yes.
So if there are 0 creditors, then this plea has to be taken, and if the court is satisfied with that plea, it can do it. So that's the solution, which I think can be tried.
No, the CD has the way up to Supreme Court, they will go and get the order in their favor. What about the CIRP cost? What about the fees to the RP? Who will pay?
Right. The RP cost is one of the most contentious issues on all these discussions. Like I have also cleared the examination and done the training of the resolution professional. The reason is that RP, a resolution professional as a profession, is a typical mix of accountancy professionals, CS, and legal professionals. But as in the legal professional, the fee has not been regarded as a sacrosanct by various authorities. The first thing which has happened in this thing is that initially there was a huge amount of fee which was agreed. In the falling company, nobody wants to pay. So, irrespective of the fact that the COC has approved or not, once there is a dispute about the fee, it goes to the IBBI. But IBBI doesn't pay. It only directs the parties who wants to pay or who doesn't want to pay. So, as a resolution professional, despite there is a judgment, in one of the judgments, I was the counsel, and where the Supreme Court has held that it was in a case of a valuation. I was representing a fellow professional who was a valuer in that particular company, and Supreme Court has made directions to pay. But there is no mechanism whereby this can be enforced. So typically, if there is a COC, if you can't recover in the resolution plan, in the liquidation, and if it has been approved, ultimately to file a civil suit or something like is the remedy. But who will pay? Obviously, the Supreme Court is not going to pay, IBBI is not going to pay, and one has to go before the person who is running the company. And there is a lack of regulations which should be addressed by the IBBI. But since the very beginning, they have chosen not to do, and that has led to various malpractices as well. So many of the people are not joining the IP profession, or even after qualifying, they are not doing it because there is no guarantee of the fee. And two, if there is no guarantee of the fee, there is a guarantee of work. Whether you are getting the fee or not, as a RP, you are supposed to perform your duty. And thirdly, even if you are doing, you are on the top of it, has to incur the cost of other fellow professionals whom you appoint. And after doing all that, there is no mechanism prescribed where you can actually get your dues. The only section 53, it says that it gets the priority. Okay, but it actually not doesn't get the priority. Like priority is one side. Even if they write in the resolution plan, ultimately it has to be recovery application has to be filed. Lately, and the NCLT and NCLATs have decided to give a lump sum money to the resolution professionals at the time of disposal of these applications. So whenever is 12 is accepted, they are giving a lump sum amount. In some NCLT it is 2 lakhs, some NCLTs it is 5 lakhs. But it is very difficult to convince the judge to pay the actual cost. Reason being, they are unsure that a person who has performed the duty for few months can be entitled of 1 crore or 2 crore, which might be the saving of a judge for the entire lifetime, if he only depends upon his regular remuneration or doesn't have any extra source of income. So that has a contentious issue, and you have stated it so rightly. So when you are moving to the Supreme Court and you are a party, you must make an application. And normally an order is passed, which will be a lump sum amount. And it always depends upon the judge to judge on that particular day who is sitting there and what is his outlook towards the fee. Sometimes they are very generous and sometimes they are very conservative. So the answer, the final one-line answer is, when this application is going to be made before the Supreme Court, there has to be an IA interlocutory application to be filed by the RP seeking the money, and probably the court will pass the order then and there. Does that answer your question, sir?
That is true, but one doubt, the operational creditor is a foreign company. When the person authorized representative who is attending the COC, can he be made liable as an agent of the foreign principal for the payment?
Theoretically, yes. but practically it will be very difficult to implement.
Okay.
The theoretically, yes, probably you will be, but who will determine whether he is an agent or not, whether he is liable in the personal capacity or not, whether he is an executive director, non-executive director, what is his remuneration, where the assets are located, can you enforce it as a decree? There are so many open questions in this question.
So he's the legal counsel of that operational creditor who represented before NCLT, but he also attends the COC as the agent of the operational creditor.
No, the legal counsel will never be responsible.
No, in his capacity as legal counsel, he is not responsible, but in his capacity as the agent, taking the power of the company before the COC, he is responsible. Is it not?
I don't think so. I have a difference of opinion in this regard because even if he is attending the COC on an authorization, all the lawyers do appear before the court on an authorization. This doesn't make them a client.
Okay.
So if you ever get time and if you read the wakalatnamas of any case, irrespective of the forum, there is an element of agency or authorization whereby a person or a company or somebody authorizes a lawyer to represent him before the court of law or before any authority, whether judicial, quasi-judicial, or etc. That does not make that person liable. Only the principal is liable. Even in the case of agency stricto sensu, for the act of an agent, principal is liable. For act of principal, agent is not liable.
No, for foreign principal, agent is liable as per the
That is
Agency Act. It's a foreign principal, no? That operational creditor is a foreign principal. He authorizes by apportionment for representing before COC, giving him power to give his decision on resolutions.
which section, like, could you elaborate, like, which section says that if a foreign company makes any idea?
No, there is a provision. I am not able to give you immediately. There is a
Just give
provision.
me.
Under the Contract Act, there is a provision for the foreign principal, agent is liable personally. Like undisclosed principal, foreign principal, agent is liable for personally. Anyway, leave it. Just for your information, I'm telling you.
Yes, there is some provision, but I don't think the lawyers are covered on that. But it's completely a factual thing. I'm sure that it will be very difficult to prove that. I think there is a rule in IC. You are a chartered accountant, sir?
I am a company secretary, cost and management accountant, and MBA.
Okay, so you just check. I think there is a rule in ICA as well, which says that as a professional, they are not liable. And there are something Bar Council Acts and Regulation also in which they are not liable. So Indian Contract Act is normally applicable when the commercial duties are performed. Attending the meeting is, I don't think it's a commercial duty, but I'm not sure. So I will not like to say 100% which way is correct or which way is not correct.
Okay, no problem. It's a good enrichment of knowledge I get from you.
Thank you, sir. In fact, I learned that from you. I never examined Indian contract. I read it like multiple times. So I got the section. This is section 230. 230 of the Indian Contract Act. Okay.
Yeah.
So, as a general rule, the agent is personally liable but creates a presumption of a contract to the contrary in three cases, including the contract is made by an agent for sale or purchase of the goods for a merchant resident abroad. So I think this will not be applicable. This is the only one section in Contract Act section 230 which deals with it, and I think only it in respect of the goods. So it says that agent cannot personally enforce nor be bound by the contracts on the behalf of the principal. It starts with a negative. In absence of any contract to that effect, the agent cannot be personally enforce contract entered by him on the behalf of his principal, nor he is personally bound by them. There is a presumption of contract to the contrary. Such a contract shall be presumed to exist in following cases. One, where the contract is made by agent for sale or purchase of the goods for a merchant resident abroad, where agent does not disclose the name of his principal, where the principal, though disclosed, cannot be sued. So that section 230 will not be applicable, 230 of the Contract Act. But yeah, it's good to know. Okay. good to know, but there is something.
Okay.
So thanks for that question. That really helps.
Yeah, thank you.
Sir, this is CMA Manjula. Sorry, my camera is not working. I don't know why. I try to. The thing is, now I heard that once the case is admitted, you can make the operational creditor while admitting the case. You can make the operational creditor pay all the dues in case of 12A applications. In case that is the NCLT, that is IRP cost and all. Or the RP fees, whatever it is, the operational creditor should pay once it is admitted into NCLT. Is it true?
Yes, actually, the Delhi NCLT is giving 2 lakhs upfront. Mumbai NCLT is giving 5 lakhs upfront whenever an operational creditor application is admitted.
The operational creditor will be made liable to pay at least the RP fees, I think so. Previously, it was not so. In 2019 and all, when I have handled many cases, it was not so. Now,
absolutely true.
Yeah. That is one way good move. Otherwise, I have not got fees for so many cases, to be frank.
Yeah, it's true. It's almost every RP has some experience with non-payment of the fees in some of the projects he has handled or she has handled. That's true.
Yeah. Thank you, sir.
Thank you, Manjulaji, for the feedback and the questions. So 29A, 12A interplanes. So post-liquidation bar, 12A is not maintainable. Then the BYJU'S section 11 was the question. So BYJU'S says that 11 has limited applications. And post-liquidation bar, if there is a so these are like all of you know how the things are going. So another thing is the dissenting creditors and what is their rights. So dissenting creditors, there is a wisdom of the majority which prevails. And there is an interplay of the dissenting creditors in 12A as well. So the question is, in the 12A is yet to be settled, what will happen for a creditor who does not get the amount or does not give assent under the 12A. So whether he is entitled to receive the entire amount of his dues. So those are the things still open. What is being entitlement is given is the minimum liquidation value. But typically, if there is no real estate involved, the liquidation value can be easily zero. And but yeah, the law has been well settled as far as their primacy in the payment. So in case there is a resolution plan, they has to be paid in preference to the assenting creditors that is there. The operational creditor do not have any influence whatsoever. And there is a growing feeling in the NCLT, NCLAT and all the stakeholders that it may not be a sound policy to keep the operational creditor completely out of the resolution process. And what will be impact if you want to keep them, and what is the impact of actually recovering? Perhaps when the IBC as such an act was enhanced, there was too much focus on the recovery by the financial sector because it is the backbone of the economy. And the dirty dozens that nomenclature was having around 25% of the total exposure at that point of time. But that yardstick is not applicable or is not correct when it comes to MSME or comparatively small companies. And therefore, there are discussions and there are views and counter views regarding the participation of the operational creditors in the decision-making process. How it will be evolved, what will be the next thing will be clear only when the amendment proposal goes through the parliament or if it doesn't go through the parliaments. So another thing which halts across the industry is the transactions. Preferential, undervalued, extortionate, fraudulent, wrongdoing. The difference is obvious in the name, but it is very stark when you see the section 50. Section 50, you will find any judgment which defines extortionate transactions. Why it is relevant, and hardly it has been agitated, that there is no definition which can be applied uniformly for extortionate credit transaction. For an example, if there is a credit which is given at the rate of interest of 24%, and there is a penalty of another 24%, and there is a compounding on the top of it, the interest rate can go easily beyond the 30% to 50% of the total amount borrowed. Just like a credit card where it can reach around 48% or 50%. There is hardly any business, be it India or be it abroad, where the money can be doubled in a period of 1 or 2 years. Or if it is there or there is a promise to double in that much short period of time, it might be a Ponzi scheme, but it's not a regular business. But for some reason, there was some kind of clarity at some point of time when the Usurious Act used to be applicable, Usurious Loans Act, there was an act to that respect. Then the banking sector or regulated sector was completely taken out of the purview of this act. Maximum lending is by these institutions. And so far, regulators in India or the decision-making bodies in India has not come out with a clear-cut definition of what interest rate is harmful for the economy as a whole. If a person is not credit-worthy, it's better not to give the credits. Rather than giving him the credits, putting the system at peril, and then penalizing him for taking the credit. A good number of loans where these statistics are based like this much was the recovery, 40% was the total recovery. If you evaluate those claims, there might be a 100 crore loan, but the interest will be 500, 600 crores. So the time value of the money is there, but somewhat these claims are exaggerated, not justified, and there is a significant room for improvement of these definitions to make it a very healthy market. The next kind of challenge is the undervalued transactions, very easy. All the transactions which were below the market rate, performed 1 year, 2 years, they are undervalued. But the question is, who is able to realize real value when the company is in the stress? And the valuation based upon which these are titled as undervalued transaction is itself doesn't have a sound base. So take an example, if some company is in the distress, they have a land parcel, they want to avoid the insolvency, they sell it to some person. Since it is a distress sale, they will not be able to realize the money. And if the full potential of it, and next day when it is admitted, just a second. Next day when the petition is admitted, somebody is going to question that validity of that transaction itself. So these are the tricky applications. There is no yardstick which is absolute and which creates the problem for the tribunal to adjudicate on those transactions. Third, preferential transaction, almost the same story. There isn't preference given. But again, proving it is a challenge and difficult. And lastly, fraudulent and wrongful trading. I think this is one of the most unclear section because theoretically it seems justified, everything seems okay on the face of it. But actually when somebody reads those judgments, they were termed as fraudulent only because they were undervalued or they were preferentials. The fraud itself involves an element of malice and very difficult to prove. Two, fraud, if any, was committed by the promoters. The recovery can only happen through the promoter who is already in personal insolvency. But the transactions are, if so declared, that the rule, like the principle is yet to evolve at the level of the Supreme Court. There are contradictory judgments in the NCLAT. One which says, in the Supreme Court, in one of the judgments says that it can't be recovered from anybody else because this provision is para materia with another provisions of the Companies Act where only recovery is given against the company. The bare reading of the section also makes it clear that the recovery is against the promoters when an application is made by the resolution professional. But a contrary judgment is there, which says that no, the intent is this and that. So in that fluctuation, since the law is so volatile, it's very difficult and it's very challenging. In some of the cases, you find that the money was given to some person who was and the transaction was canvassed something else, and the person can dig up the entire transaction 5 years, 10 years back. That will not serve the purpose of the insolvency for sure. So valuation is another challenge because whether it's illegal transaction, whether it is IM, whether it is form jury, whether it's 30 distribution, 53, or all of it is litigatable, and there is lack of certainty in all these things. So there are reforms, but they are not sufficient to address the problems of the market. One of the reasons the valuation is not sure because the real estate transactions is the largest transactions which are taking place. And in real estate, the title itself is under the challenge in most of the cases, which can't be valued. Disputed title, it is impossible to value. Secondly, all the lands has some kind of user issues, whether it's an agricultural land, industry is being run, industrial land, reason IT park is being run, IT park permission, FAR is LU. And for those deviations, there is no rule or a definite yardstick whereby a value can be given to an illegal thing. Though there is a value, but it is illegal. I don't think that IBC can capitalize on illegal valuation, and therefore the challenge remains there. Then the liquidation is another trap. When the value is not correct, how the liquidation value can be correct? So floor, ceiling, methodologies is also challenging. And there are only 3 types of assets which can be valued as such, but what about the intellectual property rights? In some of the companies, the value resides in the intellectual property rights only, and it's very difficult to quantify. There is completely lack of clarity on those kinds of assets. Another thing could be the licensing, which is still pending before the Supreme Court. The spectrum is a national asset. It can be used by the companies, can't be sold off. One view is by that it will go as per the provisions of the IBC because IBC overrides everything. But at the same time, there is another argument that it can't take away the rights. It's only a license or a lease. Similarly, in the case of the landowners, where the Supreme Court has held against them in some of the cases that they are like promoters or there is an argument. But at the same time, under the IBC, how you can snatch away the property of the person without paying him anything on the ground that he has a relationship with the company. So law is bound to change, will change. And in this volatile scenario, all the industries, irrespective of the segment, they will face challenges. So what happens because of these challenges is that different kinds of industries face different kind of challenges. So sectors, let's come to the sector specific challenges. So I intend to wrap up at around 4:30, not to bother you with too many things. And if anybody has any questions so far.
So on section 66, I want some clarification regarding third party concept involved in Glockridge judgment matter.
Okay, so what is the question, sir?
Actually, NCLT is treating all the stakeholders who dealt with the CD as third party, excluding the directors, considering the Glockridge judgment.
Right.
But the scheme of section 66 is not so. Section 66 provides that directions can be given to any person.
Last sentence I could not hear. Could you repeat?
Section 66 of the IBC provides that directions for in case of 66 application can be passed against any person who was a party to transaction.
See, that's what the same thing I was arguing. So let's read section 66 together. Do you have it in front of you, sir?
I will open. Yes, please.
Yes, open it. It's very interesting section as such. Let me just open it in my front and then I'll read it for you. How it has been read and what is the... So I read this section multiple times, maybe 5-10 times. And so far the interpretation which has been given by Justice Jain doesn't support the plain language of the section. Let me, just a second. Section 66. Give me a second, let me open it in front of me.
Please.
Section 66. 66 of the...
If you permit, I can also share it on screen.
Yeah, please. I think, you please share.
Okay, just a
minute. That will be helpful because I'm using the iPad, so I'm not able to.
Yes.
Yeah, please share it. I have stopped my screen share.
Please, sir. Is it visible?
No, not so far. But yeah, it's come. Yeah, that's great. Now it's visible.
Okay.
So let me read it for you from the one perspective, which I think is the same as the last Companies Act. Okay. I'm reading from the similar section exists in the Companies Act as well. If during the corporate insolvency resolution process or a liquidation process, it is found that any business of the corporate debtor has been carried out with the intent to defraud the creditor, the corporate debtor, or for any fraudulent purposes. So first, the ingredient is intent to default the creditor.
Yes.
There has to be an element where you are reducing the total amount payable to the creditor by resorting such a transaction. By a fraud means not disclosing proper facts or manipulating the documents. An element of the fraud has to be there. Then what happens? The adjudicating authority may, on the application of the resolution professional. So only person who can move an application is the resolution professional. Pass an order that any person who were knowingly parties. So against whom it can be passed? Who were knowingly parties to carrying on the business in such a manner shall be liable to make contribution to the assets of the corporate debtor as it deemed fit. The story doesn't end there. The story starts in the second part. On an application made by the resolution professional, during the corporate insolvency resolution professional, the adjudicating authority may, by an order, direct that director or partner of the corporate debtor, as the case may be, shall be liable to make such contribution to the assets of the corporate debtor as it deemed fit. So the only two persons who have been made liable in this section on an application of the RP is the director and partner. That's it. So the definition which NCLAT's judgment, I have read it couple of times, it goes against the plain and simple language of the section itself. Because this very section was interpreted in the Companies Act. And there is a judgment which is in the IBC as well as the Companies Act, where the Supreme Court has held that under this section, only directors and the partners can be made liable and not the third parties. Assuming that it says any person, let's take a definition of any person, like any person can be made liable. That any person doesn't found mention in the clause 2. The first part use any person. So everybody is reading the first portion, clause A, where the pass an order that any person who were knowingly parties. So first knowingly parties or any person. But who are those any person is only two. Directors or partners of the corporate debtor. It doesn't, section 2 doesn't talk about the third parties at all.
No, sir, I disagree with this because subsection 2 and subsection 1 are two different provisions, not interlinked in any way.
That's how that judgment, that's how the Supreme Court and NCLAT differs. Okay, so if you read section 1 independently of the section 2, then you say that any person is entire world. But if you read the section 2 carefully, the application, one says that application made by the RP only. No third person can make an application. And then you read the section 2, if the RP make an application, that any person is only these two people. So I'm not saying that the interpretation is NCLAT is wrong or the Supreme Court wrong, but there are chances of the interpretation which might tilt in the old classical way, where only the person who can commit the fraud. Okay, take an example. A promoter, I'll take a realistic scenario. Let's take a hypothetical scenario. A person is really going, or he's thinking that in 1 year I will not be able to pay. And the banks, financial creditors, or whatever the creditors, so let me siphon off the property and run away. whether by any chance of imagination it can be said that that person will be dumb enough to tell the other party that I am going to cheat my creditors and you help me in it? Or that third party will ever take the stance that he told me that I am going to cheat my creditors, but still it was financial advantages to me. So orally we entered into an understanding, or writingly I communicated to him that you cheat your creditors, I will help you. It's so unrealistic on practical terms to prove this transaction if it is interpreted as any person. So technically, the only person who will be privy to the transaction or knowingly entering into the transaction is the party who is trying to cheat the creditors, not anybody else. It can't be, because as a buyer or as a purchaser, I will never buy a property or enter into any transaction which implicates me and takes away the advantage itself out of me. So, assuming it's a scenario like this, you buy, you are in the market, okay? Now you open any sale deed, 100% of them. They write one paragraph. Since the seller is in need of money, he is agreed to sell this property for so and so consideration. Of course it is. Otherwise the transaction will not happen. So it will be so unrealistic and far-fetched and so cumbersome if you put the onus on such innocent buyer that you prove that he made a statement that he needs the money, still you entered into that transaction is fraud. This entire thing, which I feel, it's my personal opinion, though I can argue on both the sides depending upon whom I am representing, but it's very difficult to prove. Two, it's a very unrealistic scenario. You can't see anybody without examining the evidence in full to make him guilty.
Can the term used, any person, stand redundant in this scenario?
So far, the interpretation from the Supreme Court, any person means, you just drop me the personal message, I'll give you the judgment of the Supreme Court, which I have cited in few of the arguments when I was appearing for the other people. So that judgment specifically says that any person means only the directors. That appeal came from a Guwahati judgment. It's a very simple judgment, and even if you read the Companies Act section, this was the interpretation which sustained for like decades together.
And even that judgment was passed in a different context, in a transient bail matter, Glokri's judgment. Still, it will be applicable to financial transactions committed by the fraudulent, in a fraudulent way.
I am very happy that you asked this question. So I have a take on it, completely different one. Law is not mathematics. A person's feeling that he is just and right is entirely unjust and arbitrary for the other one. It's the whose version you hear the first. So as a mediator, sometimes I do lots of mediation and lots of them are matrimonial. Okay. And even every person hears all this. So in law, what happens is that if you hear the version of first version, either it is plaintiff or the defendant, if you hear that version first, you get biased. It's humane. And you behave accordingly. Okay. Suppose one of your relatives is a wife and she comes to you and saying that my husband has beaten me, and that husband is not relative of yours, immediate relatives, then your mind is going to be prejudiced against the husband invariably. But at the same time, if you reverse the situation, the husband is your relative, maybe your niece, nephew, or brother or something, and he says that the wife has done something wrong, then even if the wife comes and thereafter says something, it will be, your presumption will not change. So in law, to say or to believe that one view will be acceptable in all coming times by a particular court is simply never going to happen. Judge to judge, case to case, it is bound to change. And this is not a clear case. And whenever there is an absolute thing, even you can see that such a simple thing, default case. So this one of the judgments of Justice Indira Banerjee, which says that there is may written in section 7 and not shall like section 9.
Yes.
There is nothing wrong with that judgment. Think of a situation, and I have represented some of those companies as well. Since you are running a company, you get a government contract. You execute the government says that your bills are approved, but treasury doesn't have the money. Your vendor comes to you and says that pay me the money. You say that I don't have the money, but I have the approved bill. But you have committed a default. So what is actually happening? The government is saying that you should not default, but I'm not paying you the money. So you have to default and I will put you behind the bars. Okay, so similar thing is happening. That's very simple scenario. Section 7. It's very much complicated in section 66. In section 66, you are implementing a third party who was not privy. And it can't be proved easily that he was privy, except that one liner, which is always written in all the sale deeds. Have you ever seen a SEBI judgment where SEBI penalized for insider trading a direct evidence? Hardly any. So if a thing which is bound to be clandestine, it's impossible to get a direct evidence. And unless a direct evidence, you should not presume that person as a guilty. Then how come the IBC, without looking at the evidence, some judge says that, no, I feel that you are chore. So if you are on a receiving end, you will see that the section 66 has to be read verbatim. And if you are on the other side, a creditor, then you will see that the 66 has to be read like any person. Because he has the money. Director doesn't have anything. So you are going after the person who has the asset. But the whole argument is whether it can be read both ways. Yes, the judges have already done it. The final verdict is yet to come.
Whether this is challenged in Supreme Court in any case, sir?
Actually, the Supreme Court challenge has not gone from NCLAT so far. I haven't come across. It might have gone. I haven't come across, and because these cases have started coming recently, because earlier the section 66 applications were not decided altogether.
Because I am aware of the order in which NCLAT was not inclined to accept this interpretation, and can also share that order on screen.
I have to fetch it out, but I know the judgment which held that any person is liable is authored by Justice Jain, bench number 4, Delhi. And that's what is the last judgment from the NCLAT. Previously, the opposite was held by I think the bench number 1. And
Royal India judgment I can share with you
if you open it, I'll tell you it is which one, who is the author, because normally I remember by the name of the judges.
Okay. Just a moment. This is the relevant paragraph.
No, you just show that who has authored the judgment, and that's
Okay,
it. Okay. Either it will be on the top or it will be on the bottom.
This is the Ajay Das Malhotra, technical member. And the order date is.
Yeah, it's a different one. It's not. It's a different one. What was the date of this judgment?
Yes, I'm checking just date of judgment.
Yeah, this is one. This is one I'm saying. This is what you are referring, Justice Rakesh Kumar Jain.
Okay.
So this is the judgment where he said that any person means any person. But
yes.
There is another judgment by the Supreme Court. So we are referring the same judgment. Okay.
So of Supreme Court and CLET.
Supreme Court.
Okay.
Just give me a second. Let me try to pull it out. If I can, I'll just try. I think it was authored by. It is only 2-page judgment. It comes from the Guwahati High Court, and
No, which Glokrit or some other you are looking?
I'm just trying to find out the file where I have argued. Give me a minute. So I cited that judgment, and so let me open that. I have. Just a second. So this is, you can note down, this is a judgment called Gulkrit Capital Private Limited versus State of West Bengal.
Yes, in this case, third party concept, yes, we are discussing about this judgment.
Yes. Okay, that was a different context, but where it was held specifically in reference to Section 66 from the Guwahati High Court, that any person doesn't mean any person.
Any person doesn't mean any person transaction because in case.
So I'll read the conclusion for you. We are of the considered opinion that in such a circumstances, it is for the resolution, professional or successful resolution, the case may be to take such civil remedies against the third party for recovery of dues payable to the corporate debtor, which may be available in the law. The remedy against third party, however, is not available under Section 66 of the IBC, and the civil remedies which may be available are independent of the said section. So 66, third parties against can't be invoked.
And one more point, sir. In case CD sells some goods, there are some fictitious transactions between Mr. X and the CD. CD is beneficiary. CD has obtained money from the third party, or Mr. X has obtained money from the CD. Then how Mr. X could be a third party in case there is a transaction between the CD and Mr. X? They are the parties to transaction.
That's the way you look at it. So the parties to the transaction and the litigation, third parties are not parties in the IBC proceedings. In IBC proceedings, the parties are creditors, shareholders, or ex-promoters, resolution professionals, etc. A person who is not in the ecosystem of the CD or a stakeholder in the CD is not a party. That's how it is. It will be read when you try to read the third party from the perspective of the buyer. Okay, so the parties to the transaction, yes, if you are isolating the transaction, but that's not a dispute inter se between the parties. Here in IBC, the proceedings are inter se between the stakeholders of a corporate debtor. A person who is not a stakeholder in the corporate debtor is not party to the IBC proceedings. Otherwise, what would happen that a person who is neither a creditor nor a shareholder nor anything will be entitled to move an application under 60 sub clause 5. So the world of argument is very tricky. It can be read both ways or multiple ways. And therefore it is not absolute. And that's why most of the resolution professional who is not lawyers feel that the judges are not consistent. But the reason is the nature of the profession is not consistent. There is no 2 plus 2.
Okay, thank you.
Welcome, sir, and thanks for the discussion. Like it really helped me. Otherwise, it was completely going blank. Thanks. And anybody else has a question? Okay, so going back to the original theme of the presentation. So I wish to give some sector-specific challenges and then wish to conclude in 10-15 minutes because I have received a call where I have to join another proceedings before. So can you see the slides? Anybody can say yes?
Yes, please.
Okay, thank you. So JP Infratech, etc. So we have talked a lot of our. Let's talk about. Come on, pop up. So real estate challenges. So what is the challenges of the IBC? Since it is one size fit for all. The challenge in the IBC for the real estate sector is the definition of the landholders. Whether it's a Noida Development Authority or the owner, they have not been given any say in the proceedings despite the fact that they are one of the stakeholders. 2, the IBC process itself has not proved to be very efficient in managing the real estate projects. 3, the value resides in the real estate, which is actually not owned by the company which is going under the insolvency. As the selling company is different, the project construction company is different, the landowner is different, and so there is a lot of bifurcations. There is no one scheme which can bring all the stakeholders of one project in one go. And therefore, the real estate projects are very difficult to manage. The steel manufacturing has seen some of the very biggest cases because there was the value in the factories itself. All the landmark judgments, be it Bhushan, SR, Electrosteel, Ashoka Industries, came from the steel industries. They are the backbone and one of the largest borrowers of the banks. Therefore, they were resolved comparatively faster, but the process did not move even in their cases in a structured manner. It involved the people of lots of livelihood. As far as the telecom companies are concerned, the issue that who owns the spectrum or whether the spectrum should go along with the IBC proceedings is still something which is to be decided by the Supreme Court. To my understanding, so far there is no judgment by the Supreme Court. It is still pending. There are cross borders and the group insolvency is also a problem where the companies have a lot of foreign stakeholders. How to resolve them? There are provisions which they are trying to introduce, but so far they have not been introduced. And so what needs to be improved? There has to be reform which has to happen in the real estate sector. So since the most prevalent is the real estate sector because there are lots of stakeholders. The challenge is not only limited to the number of companies which are involved in a particular transaction. The challenge is far bigger. And for all those insolvencies, the challenge is bigger because there were no proactive action by the regulators when the problems started emerging. And even today, some of the areas which requires improvement are not taken care of. Take an example, title deeds. It's one of the biggest problems in most of the states. It creates problem in the valuation. It does not help in executing the transactions. And because of this, the business took the advantage of the system. Like there were times when the projects were being advertised even when the land was not purchased and the people were buying it. No action was taken. Then there came a time when the people were buying the land and without starting the work, sold the entire projects with the promise that we will pay even the bank installments if you buy from us. Is the subrogation, is the, what you can say is the scheme which is now being considered by the Supreme Court.
Subvention scheme.
Subvention scheme. Third, still there is no law which actually creates an ownership title when the plans are approved. So most of the projects, the people say that promoter has sold it for 10 times or 5 times. But when the things are being sold in the air, there is no definite mechanism where they make the description authentic and verifiable for the purchaser. Like you can't actually see the flats. So there is a lacuna on the law on the part of it. If you are going to buy a property, you can actually see that this is the description of the property. So the no third party can create an interest on it. Fourth, there is a huge discrepancy in the lending rates. Why the subvention scheme became popular? Because if the builder goes and asks the market, give me 100 crore of rupees, the market says, pay me interest rate of 18% plus 9% penalty plus compounding, roughly taking 25% interest rate or more than that. In 4 years, which project is complete? None of it. None of it is viable. So the interest rate has no correlation with the project for which the interest was given. So they devised the subvention scheme because it's now 8%, it becomes viable. The cash component in the transaction is huge. Valuation become a problem. One flat is sold for 50 lakhs because the 50 lakhs was paid by check, remaining was paid in cash. The resolution professional still struggling what claim to accept. The receipt in the bank account or the receipt which he has produced, photocopy, the buyer has produced. How to value them? So these are some of the chronicle problems for the real estate sector. Take an example of the power sector. The power sector faces the challenge that the buyer is the government and they never pay up on the time. So the person who is giving the license, say to somebody as a hydropower plant or a gas power plant, the permission to construct, to run is given by the government. The cost is almost decided by the government because they know how it was constructed. Then your purchaser is only the government. You can't sell it to somebody directly to the third party, otherwise you have to pay the wheeling charges and etc. So your biggest purchaser is the government. The government doesn't pay, and some person who is sitting there, operational creditor for 1 crore default can come, and the entire sector goes into a spin. That's a challenge for all the sectors which are highly dependent upon the government. Third, which is across the sector, is the people take the loan only because they are unable to manage their finances. Even if they are profitable, they have to manage their financial cash flows day-to-day basis. Therefore, they have to take the loan. That's why the loan is being taken. Healthy company will never take a loan which doesn't require the finances. They will turn only when they want to expand or when they are unable to meet their cash flow things. For a default, one single default, like anybody can pull the chain of the train and the company goes into the spin, is not a viable solution for most of the things. All the companies in a nation who wants to grow can all the time cannot be surplus. If that is the case, the banking industry will collapse. So typically one default or a three default thing, one default thing is particularly capricious. There is no full disbursement. There are OD limits issue. There are mismatch of transactions issue. Then another, like you take any other sector which is dependent upon different kind of market forces, then it needs a different set of rules. The Google philosophy, one size fit all, may not be suitable in the AI world, where everybody need a personalized solution. To some extent, the legislature is moving towards the sector specific thing, but probably more is required to be done. Why? Because challenges are different, stakeholders are different, and one paracetamol is not applicable to all. So we are moving towards that direction, and probably this trend will go for some point of time unless the things improve. And that's what my take is as far as this presentation is concerned. Anybody has any questions so far? All are happy, satisfied?
I once again want to come back to section 66, sir. It will take 2-3 minutes only, sir.
Yeah, let's go back. It's healthy discussion.
Yes, please. Let me to share first.
Yeah, let me stop this.
Yes.
So I stopped the sharing. Yeah, you share the section.
Yes. But I want to say that the subsection 1 and the subsection 2 are the two different sections. It is very much clear from the reading.
Yeah, that's what you think, but Supreme Court did not agree with that view for some point.
Because subsection 3 support that interpretation. Subsection 3 provides that subsection 2 application cannot be filed in case of certain cases.
So
subsection, it clarifies that these are the two different sections. Subsection 3 says, notwithstanding anything contained in this section, no application shall be filed by RP under subsection 2. It does not exclude subsection 1 transactions.
Yeah, that's what I will argue for you if you are filing the application.
So there is some merit in this argument or not?
See, being a lawyer is supposed to argue what his client's case is.
Okay.
It's not the law that you argue what you feel is right. Example, if
no,
you
as a professional, there is some there is some merit or not in this argument.
So both the argument are meritorious. It's not that the other argument doesn't have a merit. It's a very much merit, and in fact, I feel the other argument has more merit that whatever manner you read, a person without on the basis of the evidence should not be punished. Okay. And there is no procedure of taking evidence and proving a thing in NCLT or NCLAT. That's the fundamental backbone of any judicial system, that if you want a person to be deprived of his property, he should be given a chance to demonstrate by the evidence that the transaction he has entered is justified and legal. Since he has not been allowed to do that and there is no procedure prescribed, the argument of Justice Jain, the bench, is inherently goes to the against the basic fundamentals. Tomorrow you go, assuming, forget about everything, forget about even 1666. Tomorrow you go in the market and some property is being sold in your vicinity. Okay, you don't know he is promoter of some company. You don't know. Maybe he's doing business or he might be a director in some silent company. He comes to you, I want to sell the property. You said, I want to buy it. Okay. And just as you say it, you enter into a transaction. And the transaction is being questioned after 5 years in a court of law, in a personal insolvency or a corporate insolvency case, that this transaction was entered solely with the intent to defraud the creditor, and there is a proof written in the sale deed itself that the promoter wanted the money, therefore this property was sold.
There could be other transactions also other than sale of property.
You take any example. Let's test this hypothesis, an example of your example. Give me some other example where it can be tested.
Okay. There are two real estate companies. One real estate company sold a property. These are the facts actually. One CD sold some property for 7 crore rupees.
Okay.
And another company was having some old inventory of clothes. About the age of that inventory was more than 15 years.
Okay.
Now CD bought clothes from that company for that amount of rupees 1 crore. Next day, after selling the property, CD got issued 10 demand drafts of rupees 10 lakh each from his bank in the name of another company. And billing was done of 10,000, 5,000, 20,000 in phased manner. And demand drafts were deposited in 3-4 months. So on the face of it, it appears that fictitious transaction has took place.
No.
But for only, sorry?
No. That's
Why?
an inference. I tell you, I have actually seen one such transaction. One of the real estate companies, they were very big, like thousands of crores. They actually purchased clothes from the designer which was worth 3-4 crores and given the real estate to that designer, and thereafter that transaction was questioned. It doesn't mean that somebody is buying property and clothes so they can't be matched, and the presumption is there, which is on the basis not supported by the facts. So that's what the problem with the entire section 66 is. There is no evidence being tested.
No evidence. Okay.
The idea is, I actually saw that transaction happening, and the transaction in being questioned. I was advising to one of the parties. My client was that clothes seller who got that property, and RP asked the question, and he says that मैंने तो concession पे दिया था. I was not able to recover, so he gave me the real estate. I was actually incurring losses even with close transaction with the real estate because my stock was more expensive than his property.
Oh.
In reality, I have seen that. So the idea is whether that interpretation, I'm not sure which one is going to prevail later on. But whole idea of NCLT doing these adjudication is contrary to the scheme of the Act, because if you want a just society, you need a system where a person who is accused of must be given a right to defend himself. If he has not been given the right, the system is not just. So thank you, sir, for your Gulshanji, for your wonderful questions. Any other question? Anybody?
Thank you, sir. Thank you.
Thank you. Manjula ji, Rangaswamy ji, Satyadev ji, anyone, any questions?
No, sir, it was an excellent session.
Thank you. You always ask the question. Somehow you did not ask this time. I remember you from earlier sessions.
Okay. But still, my view is IBC, though a lot of changes have taken place, the fees regarding RP still is a big, big, big question mark, according to me. And, if you take cases, especially when you're empaneled with IBBI and you get the cases in NCLT, it is really tough. You don't know whether you get the fees or not, but you have to. This is why most of the IPs are not taking a.
Yeah,
Fees is just country issue. For expenses, we have to fight.
Pardon?
Fees is a country issue. We have to fight for expenses incurring out of our pockets.
And more than that, you'll have to incur. In most of the cases, especially when operational creditor, files COC will, financial creditors will not be interested in this CIRP process. That is my experience. Banks, especially, they'll not be interested in CIRP process and they'll not be ready to approve the expenses also. I don't know, some steps must be taken by IBBI to, you know, to make better this situation.
Yeah, that's true. Actually, the problem is, I remember like an incident, and it was not actually pursued by the IPs. So nowadays it's not allowed, but in olden days, what happens that if a father wants to beat the son for some misdeed, what he used to do is ask the son to take out the stick himself and then give it to the father. Okay. In that very same manner, the IBBI takes the money from the IPs, a certain percentage of their earning, and
Ah,
then gives the right to beat them only.
yes. Excellent example. Yes, that is what is happening now. Now I'm scared. I mean, in 2019 and all, I have handled many big cases, but in one or two cases, I didn't get the money. I've lost money. To be frank, I don't want to help us at that situation. We have to keep going, whether you get the fees or not. So, hesitant to take cases. That's what happens.
That's what happened. And one association challenged this mechanism in the Delhi High Court, they lost it. And thereafter, nobody took it to the Supreme Court. And in fact, this was wholeheartedly not pursued by all the IPs. Otherwise, it would have made a difference. Because the fundamental principle of law that there can't be a conflict of interest. No, you can't take the money and say that I'm going to regulate you because I'm taking money from you, and I'm making sure that you may get or you may not get your money, but I have to get the returns.
Ha. Correct. Not fair.
Not fair. Not fair at all.
Yeah, and you keep seeing all the disciplinary proceedings. IPs are made the scapegoats.
I think most of the IPs will be more happy if the IBBI instead of 0.25% charges 10% but give 100% of their fee.
Ha.
Let IBBI pay the fee for the delinquent people and take 10% instead of 0.25%.
It's very difficult. I don't know how many are practicing seriously, but it is difficult. IPs are scapegoats, I feel, nowadays.
Yeah, that's true. That's true. So thank you very much, Mangalaji, for the discussion. Any questions, Sunilji, to us?
Thank you, sir.
So thank you. And I'll request the ICSI Institute to please close the meeting since there is no questions. Is there someone from the Institute? Hello. Hello. I have to join a hearing.
We may call off it, sir. We may call off it now.
The thing is that I have to join a hearing.
Yes.
But
so we may leave the meeting now. Better.
I'll just call them and then I'll say that. Otherwise, they will say that you haven't done the number of hours, so won't give the credit, etc. That's another challenge. हेलो मैम, कोई इंस्टीट्यूट की तरफ से है सेशन क्लोज करने के लिए?
हाँ सर, मैं करा देती हूँ।
हाँ, प्लीज करा दीजिए, because I want a formal closure, so all of you should get the credits. for which they have charged money.
Thank you very much, participants, and Manish sir, for taking the session and giving a valuable suggestion on the topic.
Thank you very much, ma'am. Thank you.
It's Jenny from